this is Georgia plaintiffs suing a New York defendant about statements made in Georgia in a D.C. federal court.
Well, okay, so we'll get to you'll make sense of the jurisdiction. It's forum shopping in its purest form. These are the two Georgia workers who Giuliani, made reference to having pulled out briefcases from under the table in the middle of the count. I have to refresh my memory as to what was actually potentially even false versus actually true about all this. Gets sued for defamation and gets Alex Jones exactly like Alex Jones got Alex Jones. He got more Alex Jones actually than Trump did because Trump had a summary judgment. Giuliani was default verdict for liability because allegedly he failed to produce electronically stored information. And his argument was that I can't produce it anymore because the FBI took my phone and wiped it and I no longer have access to it. And I don't know the details. I would love to have Giuliani on to explain the details as to whether or not how it happened, whether or not it's a pretext, whatever. The bottom line is he's accused of failing to comply with discovery obligations to produce electronically stored information that the judge is thoroughly convinced is in his possession. The judge, an Obama appointee, I forget his name, but I suspect you'll know.
It's her. It's the chief judge that's caused all the other problems and issued all the other crazy rulings, including the Twitter case, including stealing Trump's attorney-client privilege information. The one that governed the grand jury in the Trump case. I mean, it's the most partisan. It's the one that Congresswoman Stefanik recently filed an ethics complaint about because of her public statements cheering on these cases outside of the courtroom. So she's one of the most corrupt partisan judges in America. An honest Congress would impeach her.
And this is her name is Beryl. I just knew Beryl Howley, whatever. If you
former chief judge.
Yeah, she was just accepting an award at some American white-collar worker event where she's basically making public statements about the January 6 cases, the facts, and how basically they're all a bunch of insurrectionists, even the ones that haven't been adjudicated on yet, which is as unethical as anything can get for a judge in the exercise of their duties. So she's the judge. She defaults Giuliani and says, you're not complying with discovery. It's so egregious that even though apparently Giuliani was prepared to concede the statements that he made were false. I don't want to misphrase it. I thought he was prepared to concede that the statements were false while preserving his First Amendment rights to have said them. She says, no, you've defaulted and it's a liability verdict by default. Plaintiffs don't even have to present evidence to make their case. Boom, guilty. Now let's get into the damages. And I awarded, $100 and some odd million to all these people. There are people out there, Robert, who say, well, all he has to do is comply with discovery. Let's just operate on the basis that Giuliani, in fact, did not comply with discovery. He had the information and refuses to produce it. Can you not explain to people why, especially in the case of a defamation case where all of the lawsuit is based on the statements being publicly made, that's how someone gets defamed, that maybe foreclosed from pleading, preventing from presenting a defense might be the most egregious sanction, but bypassing the plaintiffs even having to prove their case, how does it happen?
Well, first of all, the case had no business in the District of Columbia. It is an utter joke that this case was ever allowed to be brought in the District of Columbia because the statements were not made in the District of Columbia. The plaintiffs do not reside in the District of Columbia. The defendant does not reside in the District of Columbia. The statements weren't intended to impact the reputation of the plaintiffs in the District of Columbia. So the constitutional standard, I'm litigating this currently on behalf of Robert Kennedy in his defamation claim that we brought in New Hampshire. The reason it was brought in New Hampshire is because it's quite clear in our view that the defendant targeted New Hampshire to impact the reputation of Robert Kennedy to try to hurt and impair his presidential primary campaign at the time in which the statements were made. And reiterated and republished and rebroadcast. And so what the U.S. Supreme Court has said is you can sue and libel under the Constitution. It conforms to due process to allow a state to have jurisdiction over a defendant, even if the plaintiff doesn't reside there and the defendant doesn't reside there, if the intent was to impact the reputation of the plaintiff in that venue. Here, there's no evidence of that. And so the D.C. court had no business presiding over the case. But it's so corrupt and so partisan, it dishonored its own venue requirements and constitutional due process principles to even be involved. They handpicked, cherry-picked the District of Columbia because they know how prejudiced its judicial pool is. They know how prejudiced its court of appeal is. They know how prejudiced its jury pool is. And this case, of course, proves it. Now, the second aspect is, this is what's colloquially called the death penalty sanction. My view is courts should never be given this power ever, period. You have a right to trial by jury. Courts are not at their liberty to eviscerate that. I have long opposed the doctrine of summary judgment. I've long opposed definitely all default judgments, so-called default judgments. Those should be reserved, default judgments, to where the party never appears, doesn't participate in the proceeding at all, knowingly and deliberately. It should never apply to someone who's participating in the proceedings, ever, end of story. I'll give an example. We'll be talking later about the Google case. In Google, they not only didn't produce evidence that was requested, they destroyed it. They deleted it, incriminating chats. Did Google get defaulted? Of course not. So this is much stronger than what happened to Alex Jones, much stronger than what happened with Rudy Giuliani in terms of neither one of them were even accused of destroying or deleting known evidence. Google was proven to have done so. What is the evidentiary sanction the protocol, the process calls for that respects your right to trial by jury and your right to a trial on the merits? It's an evidentiary inference. The judge gets to tell the jury, they destroyed this evidence. You can assume that evidence would have had would be really bad against them, and the worst possible inference you can make. That's it. The judges and the courts are weaponizing their power to strip juries of their rights. Now, you have to ask a bigger question, which is, just like in the Alex Jones case, here they had partisan judges in Connecticut and in Texas presiding over Alex Jones cases. Since this has come back up in the news with Alex Jones being reinstated on Twitter to a lot of fanfare by a lot of his supporters, but his critics are screaming about Sandy Hook all over again and lying about what happened in those cases in the process. When you have partisan judges and juries in your pocket, why would the lawyers or litigants in those cases against Alex Jones, why would they demand no trial on the merits? Maybe it's because they know the trial on the merits would prove their claims are false and bogus, which is what the claims against Alex Jones have always been. Most of the things people think Alex Jones said and did, he didn't say and do. And what it is here you have judges that are so paranoid, so terrified, that even jurors that are in their pocket from a partisan perspective against the defendant, they're scared if the world sees the evidence that their whole case will fall apart. So it's the same with Giuliani. Why, if it was so clear that what Giuliani said had no basis in fact and no constitutionally protected opinion behind it, why were both the plaintiffs and the judges so terrified of actually an honest jury pool, one not in D.C., an honest judiciary, which is also not in D.C. on these cases? But why were they so scared that even those judges and juries hearing evidence? This is a federal case, so there wouldn't even be a public video broadcast trial. They were scared of anybody finding out the truth about this election because they know their cases are false. They know their cases are bogus. They know their cases are factually meritless, because otherwise you don't have to do these shenanigans. Now, what it goes to show is what we warned about, and a lot of other people were mute about, which is just like when they used Jones as the template for big tech censorship and deplatforming. We said what they're doing to Alex Jones, they're going to start doing to everyone else. They're going to start stripping you of your right to procedural defenses. They're going to start stripping you of your right to speech outside the courtroom. And they're going to start stripping you of your right to a trial on the merits by a jury of the impartial jury of the community. Used to be jury of your peers. That's the Magna Carta. Unfortunately, that part's not reflected in the Constitution. But a impartial jury of your community is. And this was not Rudy Giuliani's community, the District of Columbia. It wasn't the plaintiff's community either. So they want to strip them of these rights, and they're going to use Alex Jones templates to get away with it. And until and unless this stops, until a higher court says this is garbage and no more, it's going to continue and it's going to get a lot worse. That's why Alex Jones has been the canary in the coal mine, not only about things he himself has warned about, which even people like Jimmy Dore had to acknowledge he has an unusual success track record with, but the example of what's been done to him is now they're trying to do it to Giuliani, and now they're trying to do it to Donald Trump, the president of the United States.
What's amazing is that people were watching the Alex Jones trial on the damages, and they were saying, how is he even guilty? Or how is he going to even be found guilty? And then it was like, well, he's already guilty. And people are like, I'm watching the evidence on the damages, and it's basically exonerating him on the merits, but too late, you're past the merits. Donald Trump trial, after the summary judgment, they didn't default verdict Donald Trump, summary judgment. People are looking at that and saying, how is he even liable on the merits when his bank is saying we didn't rely on the statements? We would have given them regardless. We were fighting for his business. And it was like, well, how is he guilty? Too late. He is. And I guess this, and people are going to retrospectively think they saw a trial on the merits when in fact they didn't, because they bypassed it altogether, and they're doing it to Giuliani.
And to give people the procedural trick courts pull to give summary adjudication, which let's call that what it is, denial of your right to a trial on the merits, and a denial, more importantly, to a jury trial. That's what it is. There was an argument in the New York case about whether he would have ever been entitled to a jury trial anyway. Putting that aside, it's at a minimum a right to a trial on the merits. The way judges get around this is they pretend there are no facts in dispute. Quite clearly, anybody who's watched the Trump case know there are facts in dispute. So that is a bogus application of summary judgment. It is a weaponization of judicial power for partisan purposes, being imposed and utilized in a prejudicial manner to justice, which, by the way, historically, that kind of action has been an impeachable action, whether it's a judge or anyone else. The wrongful abuse of police, prosecutorial, or judicial power was, dating back to the English days, considered a high crime and misdemeanor. First person impeached in America was Supreme Court Justice Samuel Chase for his political partisan weaponization of the judiciary to go after his adversaries. And only after he was impeached did the courts get the message, oh, hold on a second. Now, he wasn't removed. He barely survived. But all the courts learned, maybe we got to be careful with our power. If Congress is serious, they need to start talking about bringing impeachment proceedings over any of these individuals, looking at including judges who, by the way, the original Federal Civil Rights Act laws, you know who their principal target was? It wasn't the Klan. It was corrupt partisan state judges and law enforcement. That's who their target was. The federal civil rights laws should be re-examined to go after corrupt partisan judges misusing and abusing their power for partisan and prejudicial reasons. They themselves are green-lighting these cases against Trump on January 6th. Okay, you get to be the recipient of that same method of justice now because you got to establish the precedent for it. But at a minimum, until that happens, these corrupt partisan judges will continue. But what happened to Rudy Giuliani is a joke. That wasn't a trial. It wasn't even a show trial. It was a scam on American justice.
Look at this. Someone replied to my tweet saying, oh, but Giuliani admitted liability is what I believe they said. Let me just make sure. It doesn't even matter what they said. He admitted liability, so there's nothing to try anymore. This is the last paragraph of the judge's order. As discussed above, Giuliani has not engaged in any conduct that constitutes spoliation. Oh, that's kind of relevant. He didn't destroy evidence. However, out of an abundance of caution to avoid any potential controversy, Giuliani has agreed to stipulate the factual aspects of liability as to plaintiff's claim, except damages. The factual elements of the liability, that he said the words that they accuse him of saying that were defamatory. And this is highlighted by the person who's trying to convince me Giuliani admitted liability. While Giuliani does not admit to plaintiff's allegations, he, for the purposes of this litigation only, does not contest the factual allegations, i.e., I said the words. Set aside the legal defenses as to whether or not they're public figures or, single purpose, what do they call them? Single purpose public figures, that they have to prove actual malice. Set aside truth being the defense to the factual elements. The judge, and there's no spoliation, he just didn't.
In the context, his intent would go to all the issues with the election. This judge was terrified of the world seeing the truth. So, this is where Steve Deace made this dumb comment. Why didn't Rudy dispute things. And Justin Hart cheered in. These simps are
Why
destroying
didn't he provide the evidence? Why didn't he provide the evidence to the judge?
Because the judge said you're not allowed to present the evidence. It's like gagging somebody and then saying, "Why aren't you speaking?" I mean, come on.
Robert,
this is where Dace is not paying attention. Justin Hart is not paying attention. To me, these conservatives are not paying attention because they don't happen to like some of these people or they're not on their side, to the political partisan weaponization of the justice system in ways that destroy the credibility of the integrity of Americans' civil justice system, makes a mockery of it, and endangers all of our liberties in the process.
And I'll play devil's advocate for a bit. Justin Hart comes. Oh no, it was Stephen Dace who said, "Come on my show and provide the evidence." And if the judge won't let you do it there, I'm just wondering, like, the statements that he, I guess, wants him to come back and say are the ones that he's being sued for defamation. I don't know how smart it would be to go on another platform while you're being sued for defamation to make the same statements again. But I don't know what evidence they want from Giuliani. Like they say, other than the laptop from hell, what else has he shown? Well, he showed the laptop from hell. He made some statements about these two particular poll agents pulling a bag out from under a table, counting votes twice, whatever. We all saw the video. I don't know what more evidence they want him to present, as if to suggest that he voluntarily refused to provide it to the judge.
And there's no better evidence than the fact that the judge wouldn't allow him to present it. If, in fact, this evidence would impeach him, if this evidence was insufficient, the judge doesn't need to go through the procedural shenanigan of denying him the opportunity to present it. A judge only does this when the judge doesn't want the world to know the truth. If the truth was on the judge's side, the judge doesn't need to prohibit evidence of the truth from coming into the courtroom, does she?
He obviously appeals this. I mean, it's a no-brainer. With the award of 100 and I don't even know.
Another part of these absurd verdicts, which started with the Alex Jones case. Billions of dollars. Are you kidding me? That was ludicrous. People like Megyn Kelly should be ashamed of cheering on some of those absurd verdicts. I get she's sensitive on Sandy Hook issues because of her controversy from NBC, but that's no excuse, no pardon for cheering on preposterous verdicts that make a mockery of the justice system. People who suffered no deaths, who know no one who died, were given over $100 million. That is ridiculous.
And for things that Alex Jones didn't even say, they were getting, that FBI agent was being called names before Jones had anything to say about it.
Exactly. Jones never even mentioned him. So somebody that Jones never mentioned, that was being attacked for reasons that had nothing to do with Jones, before Jones had anything to do with Sandy Hook, gets over $100 million. These are absurd verdicts that make a mockery of our justice system. Complete mockery of the justice system. So they've got to start doing something about this and stopping this overt political partisan weaponization of the entire legal system, civil and criminal. And just as those cases, the Trump New York case has been a classic example of that, but so have all the other Trump cases. So have most of the January 6th cases. And now both are up before the Supreme Court of the United States.
And we will get to that in a minute on Rumble exclusively after we end on YouTube.